So why plan? Well, basically to have a big say in what happens to yourself or your loved ones when you can't. If you don't plan, other people get to say what happens. Probate court judges, people who you don't know may be put in charge of things. And it represents really a lot of foregone opportunities to do a lot of really great stuff for your, not only yourself, but for your loved ones, including asset protection planning. So the common documents that we see, yes, wills, yes, trusts of various kinds, but trust is a term, like if you say, oh, do you have a trust? And you say, yes, you've told me almost nothing, because that's like saying you have a vehicle. I don't know if you have a car, a motorcycle, a boat, or the space shuttle, or a tricycle. That's how varied trust can be. Other things that we've all heard of, mostly durable powers of attorney, healthcare proxies, HIPAA authorizations, and so on. A will specifies distributions of property, but only when you die. And it is often these days doesn't control very much, because what passes through probate is what a will controls. And what passes through probate is only stuff that when you die loses all of its owners. Examples of stuff that doesn't lose all of its owners when you die: joint tenancy property, where you're not the last one standing when you die. Assets that pass by death beneficiary designation, like life insurance typically, or IRAs and 401ks, and assets titled to trust. So these days, actually, most property passes not by probate anymore. Um, let's see, it's probate avoidance is something we'll pick up on the way by when we're doing planning for people, if they're doing trust planning and so forth. But it's certainly not the most important goal in our view. And also, there are occasions when we deliberately want to engineer a probate to happen. There can be good reasons for wanting to do that. So, as we love to say, what matters? Yes.
Oh, I'm sorry. And I bet so many of you have heard that too. Like, oh, you have to avoid probate, avoid probate, avoid probate, because that just kind of gets stuck in people's head, because everybody's heard that story about somebody who's, been in probate for 2 or 3 years and it's cost a lot of money. But that's not the normal story.
And most, like I said, most of the time when we're doing planning, probate avoidance will be a part of it, but I can think of one case in 25 years when it was the primary goal, and for a good reason. There was a privacy issue that this person had. What matters in planning is to maximize your odds of getting the most of what you want, the least of what you don't want. Follow that rule, and then the right tools will fall into place. The probate process is such that you petition to have the will allowed. And by the way, I just wanted, one other thing I wanted to say. Some of the things that I talk about in this webinar are, it may depend on your state. So mileage could vary, other things don't. And I'll try to remember to point those out. This is the general probate process, and it pretty much applies in all states. You petition to have the will allowed, and the personal representative, which most people know of as the executor, appointed. You inventory and marshal the assets, meaning, collect, get control of all the assets, give notice to creditors, heirs at law, and beneficiaries, pay any taxes that may be due, income and estate taxes, pay debts of the decedent, make distributions to beneficiaries, and close it up. What assets go through probate, I already talked about, so I've kind of already talked about this slide. Non-probate assets, I've also discussed. And now let's talk about trusts. There's many, many kinds. It's not like it was, 150 years ago. Only the Rockefellers maybe had them. We use them for a lot of reasons. Yes, to avoid probate, but that's really just, as I said, something that we kind of pick up as a freebie on the way by. Manage assets during life and even long after death. You can, some trusts, depending upon the state that you're in, can go on as long as there's money in them for potentially thousands of years. Other states have a much shorter duration. Asset protection for loved ones. And if you're really doing super sophisticated planning, which is not that common to do this, but you can even try to engineer asset protection for yourself. Protection of irresponsible or vulnerable beneficiaries from themselves, estate tax reduction, planning for long-term care needs, and disabled persons' public benefits, charitable intentions. The list is really kind of almost endless. Then we get to one of the most difficult issues. Yes, you're muted.
Of course I'm muted. So we're not here to talk about that today, right? I mean, we want to talk about special needs trust today. So that's why we're kind of speeding through a lot of that preliminary information. This is not a full estate planning seminar. We really want to just get to those highlights to start really talking about what we need to talk about today, which is the special needs trust.
We're just setting the stage in the context for a special needs trust. Where do they fit in? So did you want to skip through this slide, Annette?
No, we really need to talk a little bit about trustees. I mean, lots of questions.
Okay, you know what? I want you to do this slide. Would you talk to this one?
So this is, when you're doing your planning, this is probably the toughest question or the biggest question that comes up with families. And the reason it's the hardest question or the most challenging planning question is because a trustee of a special needs trust is going to be in place for a very long time. It's a person's entire lifetime, as opposed to other trusts which don't last that long. You know, a revocable living trust or some other trust, the duration of those trusts are not nearly as long as a SNT, an SNT. That trust potentially is going to last decades. And therefore, you need to be thinking not just about the trustee for now, but for a trustee succession plan. And that gets to be very complicated. You have to be thinking about somebody that can not just understand how to run a trust in general, which has, you know, 3 pieces to it: investments, taxes, and working with a beneficiary. But they also, on top of that, need to understand the life of a special needs beneficiary, which includes public benefits rules and complexity around that special needs life. So that really becomes even more challenging. And so when you start thinking about who those people could possibly be as a trustee, you know, yourself, obviously, in the beginning, and then other family members, friends, professional trustees, institutions such as banks and trust companies, the beneficiary, which is a big no-no, and then, you know, the guardian having dual roles as a trustee. You really start to get overwhelmed sometimes when you're in planning mode. And so the list for some people is long and for other people is extremely short. And with everybody, you're going to go through those options and start trying to figure out what the best case scenario is.
Yeah, and so there's, you know, these other things to, you know, that we typically deal with. You have, you know, family dynamics or personal dynamics. So, you know, should you have a sibling of the special needs beneficiary be serving as trustee or not? Lots of issues can arise from that. And then, as Annette was saying, you know, individuals, you know, they have a shelf life, and because they may die before your beneficiary, they may just get worn out or tired of doing the job, even if they're very good at it. So we have to be looking at ways that we can perpetuate the list of perpetuate the list of trustees, or we decide it's not going to be an individual, it's going to be a professional, an institution, something that doesn't have a shelf life, And then there's other issues that arise like, okay, is somebody going to have oversight who's not the trustee, et cetera? Well, I'm ready to move on. Is that
Yes.
okay? I'm getting the nod there. We have the revocable trust is the most common kind of trust. And that provides centralized asset management during life. It is more readily accepted than powers of attorney. Unfortunately, it can't manage some kinds of assets during the life of the original IRA owner and qualified retirement plan owner. We have, let's see,
It provides
I'm
for
gonna,
succession.
yeah, I'm gonna skip through this because I really want to make sure that I get to the SNTs. It does not provide asset protection for the creator. We get that
That
question
question
quite
a
a bit.
lot. Yes.
Yep.
So one thing I do
Doesn't,
want to mention very quickly, Mark, is that a lot of people will come to us in conjunction with their special needs planning, will ask about Medicaid planning for themselves
yes,
at the same time. And it's very important to understand that when you have a special needs child, very often, there's not, you can't do too many things at the same time. You're not probably going to be doing a lot of nursing home planning for yourself at the same time. And there's a lot of layers there. So you're probably not going to be setting up an irrevocable Medicaid trust for yourself if you have a special needs child. There's a lot of reasons for that. And that goes beyond the scope of this, this presentation today. But I just want to mention that your revocable living trust is not doing that kind of asset protection planning for yourself. Okay.
there's a fundamental rule. There's always nuances to things, so I'm not going to get into the nuances, but there's basically a fundamental rule that if they're your assets and you put them in a trust or some other vehicle and you can still benefit from those assets, either because you have control or the trustee can make distributions to you or whatever, it's your stuff. Creditors can get at it, public benefits can get at it, and so forth. That's a general rule. Please don't say, oh, but what about, because yes, I know there's what abouts. Incapacity documents. So this is to protect you when you're still alive, but you're not doing so good. Maybe you're, but you're incapacitated, or just maybe not incapacitated, but boy, you could really use some help. So to the extent that your revocable trust is funded with assets, your successor trustee, your backup trustee can manage that for you. Powers of attorney, same thing, but for any assets that are yours in your own individual name. Healthcare proxies, now this is a Massachusetts term. Most states will refer to healthcare proxies as something like a durable power of attorney for healthcare or something like that. And then HIPAA authorizations. Durable powers of attorney and healthcare proxies are creatures of state statutes, so you have to carefully follow the rules in each state. HIPAA authorizations are a federal deal. And so that's a uniform rule around every state. Powers of attorney. These are, generally speaking, present powers concurrent with the principal. Some attorneys in some states will draft so-called springing powers of attorney, which are only good, only effective once you, the principal, become incapacitated. Those are very problematic, and they're so problematic that some states like Florida have basically said that any power of attorney that's a springing power executed after, I think, some date in 2012 or something like that are invalid. We don't recognize them here. The principal can revoke or overrule them at any time. The authority ends at the death of the principal. And you need, like a trust, you should have a robust list of successor agents. Most powers of attorney you're going to find are cookie cutter. The attorney cranks up the exact same thing every time. And the worst thing about them can be the key powers that are very, very important to have are often missing or inappropriately drafted, most particularly gifting powers. Healthcare proxies, these, I believe, in every state by statute are springing powers. They're only good when you're incapacitated. And they're not usually very effective or useful for day-to-day decision making. Hospitals will typically, like if you go into a hospital and it's, oh, do you have a healthcare proxy or a durable power of attorney for healthcare? And if you don't, they may shove one under your nose, a fill in the blank form, and have you sign it. Those are effective probably 99% of the time. It's that 1% or so that, as attorneys, we like to make sure that we're covering when we are doing work for our clients. Problem is that if you sign one of those in the hospital because you don't have, or they don't have access to your power of attorney or healthcare proxy that you did with your attorney, is that will revoke the one that you did with your attorney and paid for. So let's see. HIPAA authorizations. These are forms that basically authorize doctors, hospitals, and other medical professionals to speak with and share information with people you specify. It does not create any decision-making authority in anyone, but also you don't have to be incapacitated for it to be effective, which is it's really useful to give people the authority or give people the ability to speak with doctors, hospitals, health insurance companies, and so forth. Other health-related documents that we're not going to get into. Living wills are valid by statute in 47 states. Massachusetts, what is it? Massachusetts, what are the other two? New York, and I think maybe Wisconsin are the 3 states that do not have a living will statute. They are still valid here, but they're not self-executing, which means you'd have to go to court to get them enforced. There are other healthcare directives, some of them enormously complicated, but the important thing, these documents are less important than they used to be, in my view. It's great that you should express your wishes. I have I get very leery of mandates and directives on healthcare providers. I think that the number one document you need for this is the healthcare proxy. Guardians for children in uniform.
Can I just
yes.
mention something, because this comes up in groups like ours a lot. When people have kids like ours, the question will often come up about DNRs and things like that. For those of you who haven't encountered this, if you are guardians for your adult children, you may not know that there's a lot of controversy in our state about whether guardians can sign any kind of comfort care orders or MOLST or DNRs. And so
say what a MOLST is, please.
It's medical orders for life-sustaining treatment. So it's really important that you seek legal counsel. And there are many horror stories about people who have, at the critical hour, needed to go to court to seek authority to withdraw care. And it's been pretty terrible for a number of families that I've been involved with. So
even though you're saying even though they are already a court-appointed guardian for their adult child.
That's right.
That depending upon the state that you're in, and you're speaking specifically of Massachusetts here.
I'm speaking specifically of Massachusetts. I don't know much about what's going on in other states in this area, but specifically in Massachusetts, it's been very difficult. If the hospital or the institution that the person is in is not, causing a problem and is accepting the decision of the guardian, then you have no problem. It's when the institution or the hospital is not accepting the decision and is requiring court authority that you have a problem. I raise that just because I understand this group. I know what our kids are like, And I do know that this question comes up sometimes. So,
But
okay,
now,
moving on.
Annette, this should not typically be an issue where we have a minor child that's an issue, correct?
Correct.
Okay. All right. In uniform probate code states like Massachusetts, I think there's 18 uniform probate code states. Instead of your nomination of guardians or conservators for your child only being effective at death, because the nomination is by will, you can appoint guardians for minor children to take effect on your incapacity or death, and you can nominate guardians and conservators for incapacitated adult and children to be effective not only at death, but in the event you become incapacitated. I say nominate everywhere except this one thing for appoint guardians for minor children, because only a court can appoint. These are official roles that the court appoints. And so you can nominate, but not appoint. All right, we finally have arrived at our main topic, which is special needs trust. So a special needs trust, like any other trust that you do, is governed by rules set out by you within the confines of trust law and public benefits law and so forth. It holds and disperses assets for a beneficiary, but what some people don't realize, and I remember when I first learned this in a previous century, there are two basic kinds. And a lot of times when you're reading about special needs trusts, whoever's doing the writing or presenting isn't making it clear that there are two kinds, and so it can get very confusing. Well, I'm going to make it not very confusing here. The two kinds are third party and first party special needs trusts. And it's really easy to tell where'd the money come from. If it came from the disabled beneficiary, that's a first party trust. It means I took my money, I funded the trust, and I'm a beneficiary. That's a first party trust. If somebody who's not the beneficiary put the money in the trust, that's a third party trust. And it makes all the difference in the world. Remember before I said this kind of general rule that I can't take my money, put it in a trust, be a beneficiary of that trust and have it be protected. That's generally true. We're going to talk about a limited exception here for these first party special needs trusts. So why are they important? Public benefits asset tests and protect assets for vulnerable beneficiaries from themselves and from others. Now, obviously, some special needs beneficiaries are perfectly competent. They just maybe have special needs, public benefits issues, but they're perfectly capable of managing their life and so forth. But all of us, whether we would be deemed to be disabled or not, all of us have potential issues of creditor protection, divorce protection, and other various threats. Every one of us, even the Bill Gates of the world. I guess I'm dating myself by saying Bill Gates instead of some other more modern billionaire. So what criteria do we have? Well, when we say the person must have a disability, actually technically they don't for the third party trust. For the first party trust, they do. What about supplement but not supplant language? You've probably seen that if you've been reading about special needs trusts. Do you need to have that? And what does it mean? Well, if your state is following federal law, so if we're looking at SSI, which is a federal program, or if we're looking at Medicaid, which is actually 50 different state programs, but is supposed to be governed under a federal umbrella of laws. If your state is following, if your state is following federal law under Medicaid, or if you're dealing with SSI, which is a federal program, all we care about is that the trust should basically give the trustee complete and total discretion about making distributions, and that's it. You don't even need to say things like supplement but not supplant. But your state may not be following federal law under the Medicaid program of your state, so be careful. I see states impose, and I teach Medicaid at the national level for graduate program in law school, and it's horrifying how all the states violate federal law when it comes to Medicaid in one way or another. So you do need to be careful. All right.
But I want to
So
say one thing about this, Mark. So
yes,
Mark is a wonderful professor, but I'm here to talk about the practical stuff. And the practical thing is this: your trust is at some point potentially going to get turned into Social Security at your local office, or potentially Medicaid at your local office. And it's going to get reviewed not by a lawyer, but by some local caseworker.
well, the frontline caseworker, yeah.
And what you want is for them to check their box. They're looking for certain things, and they're looking for that supplement but not supplant language. And that's
Yes.
why, I mean, ultimately, Mark, yes, I understand, and we all understand, you know, the law says this and the law says that, and it doesn't say this, and we don't need that. And that's all nice. But the reason that we make all of our trusts look a certain way, ultimately, even if we didn't need to have that language in there, and in Massachusetts, technically we don't need it, but we put it in there because we want all our trusts to look a certain way so that when they go through their little checklist, they can check it off and say,
Right.
oh, this looks exactly like I expect it to look. And now I know
That's
this is a
absolutely
special
right.
needs trust and it's going to pass muster.
But
Okay.
now the real, thank you. You're absolutely right. And I got a little bit sidetracked there. But the real issue here that I want to address, and it's on the slide, is people worry, parents worry, supplement but not supplant. Oh, and they worry about, you know, can this trust really help my child when my child really needs it? Or they hear the term special needs trust. Oh, it can only make distributions for certain things. Well, you can certainly write a trust that way, but there's no need to. So the supplement but not supplant language, the words like a title on the trust that says special needs, no, that trust can make distributions. Again, your state law may vary, and I use the word law advisedly there, but it can make distributions for anything. It's not restricted unless, like I said, your state is violating federal law. So we want basically a wholly discretionary standard for the trustee to make distributions. It should not be limited. If your trust says distributions for something like health, education, maintenance, and support, that's not a good special needs trust. That's a bad one and could very well be determined to be an available asset to the child, whether it's a first party or a third party special needs trust. It should have a so-called spendthrift clause, which means that the assets can't be alienated, creditors can't get at it, and so forth.
So I want to stop for a second and just say that 9 times out of 10, I get questions from very well-meaning prospective clients who come in who are, you know, trying to educate themselves and who want to talk to me about their special needs trust or their, you know, soon to be special needs trust. And there's a lot of myths out there. There's a lot of misunderstandings out there, and people will very often come in and say things like, you know, I'm very worried about what this trust can be used for, as Mark was saying, or you know, this trust can never, ever, ever be spent on X, Y, Z. And sometimes they'll come in with a trust that's already been drafted that way. And that's just not correct. The important thing to understand is it's not what's in the trust. The trust can be spent on anything. It's the impact that the distribution has when it leaves the trust. And that's where having a trustee who understands what they're doing when they make that distribution, that is very critical, okay? Your trustee can fork over a $5,000 check if they want to. but that trustee has to understand what that impact is going to be. The trust is not going to restrict or should not restrict the trustee
not.
being able to do it. But
Now we
what
do see
will happen when they do?
that's very correct. We also, I have to say, we talk here simultaneously about how trusts should be drafted, how they can be drafted, but then there's how some trusts are drafted. So we see trusts come into our office all the time that we haven't drafted that are unnecessarily overly restrictive. Trustee can't ever do X or something like that. So a trust might prohibit certain things that it should not.
Right.
And I see that Jean asked, what is HEMS? That's a distribution standard for the quote, health, education, maintenance, and support of the beneficiary. Very common term, comes from the estate tax code. Very common to see in trust, and it should not be in a special needs trust.
Other kinds of trusts.
Yeah. Other kinds of trusts, it can be fine.
Right. So let's try to take questions at the end too, Mark. Okay, so common myths. Is a special needs trust right for my child? These are great questions that people will ask. Is it my child's not on benefits now, or maybe I don't know if they ever will be, so I don't know if a special needs trust is right for us. So listen, there's almost no downside to a third-party special needs trust. They're beautiful instruments. They have asset protection. They have, because they're a discretionary trust, and because I just told you, they can be used as a support trust. If somebody's not on public benefits, they can distribute cash, and they can be used as a regular old trust. They can protect for vulnerable beneficiaries. There is virtually no reason not to use them, other than the fact that the beneficiary themselves cannot be their own trustee, and probably you don't want them to be anyway. So I think there is almost no downside really to doing it. The stigma, well, our kids have really been stigmatized with labels and have been on IEPs and have been in special this and special that. I kind of don't think the stigma is there. They're expensive, difficult, burdensome. Yeah, there's a little truth to that, and you kind of have to weigh the pros and cons, I guess, of that. So next slide. All right. So here's the differences between the third party and the first party trusts.
Oh,
Mark,
me or you?
Yes.
Okay.
Back to the professor.
Sure. Okay. So the third party S&T, this is the part of your estate plan. This is where you're going to leave your inheritance when you are kind of done, and you, what is it they say, shake off this mortal coil or whatever. So this is part of your estate plan. You're going to leave assets in trust to a third party S&T for your child with disabilities. It's intended to provide supplemental funds for living expenses not covered by other income sources. But, if there are no other, as Annette said, if things turn out that there are no other income sources, or it turns out that, anyway, it can be, the trust is extremely flexible and can be used to meet any circumstances. Mm-hmm. Anybody can establish these. It doesn't matter who it is. It can be the parent, it can be a friend, it can be anybody.
I could take a liking to your family and just say, oh, I want to establish a trust for your kid. I don't even have to fund it. I can just sign one and establish it.
Anyone can establish. There's no age restrictions. And a quote living supplemental needs trust or special needs trust, a third party living one, meaning we create it now, but we make it irrevocable from the beginning. Well, now other people can gift to it, leave money to it, etc. If there's gifting to it, well, I don't want to get into other issues like that.
Yeah, there's a few tax things that need to be considered, but
yeah, they're really actually kind of minor. And again, the trustee has discretion over distributions. Now, a first party trust, some people call it different things, but we call it a D4A trust. And the reason is because D4A is the last three parts of the longer string that describes it under the federal code, the statutory code. It's 42 United States Code, Section 1396 BD4A. So it's established by either there's limited numbers of people who can actually sign the trust. The disabled beneficiary, the parent of the disabled beneficiary, a grandparent of the disabled beneficiary, the guardian of the disabled beneficiary, and that means a legal guardian, or a court can do it. And that's it. There are no others. And before December 13th, 2016, it couldn't even be the disabled beneficiary. It can be funded, or mostly, almost all the time, it's going to be funded with the assets of the disabled person. What do you mean? What assets? Oh, well, it can come from all kinds of different sources. We listed here: settlements, legal settlements, lawsuit settlements, estate planning mistakes, after discovered assets, overflow of SSI or SSDI payments, child support or alimony payments, maturing uniform transfer to Minors Act accounts, custodial accounts. And parents and grandparents can use it for long-term care planning. I'm just going to hit on this super quick. Let's say that an elderly person, maybe they're like in their 80s or 90s, something like that. They're heading off to a nursing home, and they're like, uh-oh, like, what am I going to do here? I got all this money. I don't qualify for long-term Medicaid. I'm going to wind up, spending down all my money on the nursing home at $12,000 to $15,000 a month, at least if you're in Massachusetts. Oh, look, I have a disabled child who is not yet turned 65, or I have a disabled grandchild. I can take my money. Let's say I have a modest estate, $300,000 or whatever. Maybe all I have is a house and a little bit of money, whatever. I can transfer all of that to a D4A trust for this person I love. And I can make that transfer. Normally, I have a 5-year look back. I have this big Medicaid penalty. I won't qualify for Medicaid. I can make that transfer, not disqualifying. I can qualify for Medicaid the next day. So anyway, that's a really important point about these D4A trusts. The real trade-off here is I'm a disabled person. Maybe I have $10,000, $50,000, who knows? I can transfer all of that to this D4A trust, and all of a sudden, magically, it doesn't count. It's not countable for public benefits purposes. Now I'm under $2,000 if I have a $2,000 asset limit for SSI or some forms of Medicaid. Great, now I qualify. Trade-off is, hey, you know what? If there's any money in this trust when I die, Medicaid gets paid back before the money can go to anybody I might want it to go to when I die. To me, that's not a bad trade-off. So that's the payback provision. Is very similar to a state recovery for Medicaid. It has to be established and funded prior to age 65. There's also this creature called a pooled trust, a D4C pooled trust. Somewhat similar, but we're not going to, I don't think we really have too much. Do you want me to talk about that, Annette, or should I move on?
Nah, we should move on.
Move on. Okay. Trustees' responsibilities.
Yeah, we talked a little bit about this.
Yeah, well, like any trust, right? We have to do all of these things that are on this list. None of these things are unique to none of the first four things are unique to a special needs trustee, but that last one is hire advocates and care managers, and also know the public benefits rules. And really, a good special needs trustee is going to need to know more about that beneficiary, that individual beneficiary, than the trustee of just a typical trust would have to. Selecting the trustee, as we've talked about before, hardest part of the planning. Should we go through this any, or we already kind of covered this?
I talked about that too already.
All right. What we love most, I think, I would say, I mean, it depends. If a professional trustee it really seems to be the right choice. What can really be great is the professional trustee coupled with family oversight. It goes by various names, like a quote trust protector, which name I don't really like very much, but a trust protector, something like that. Somebody who has the ability to oversee. Go ahead.
I just wanted to mention that we did a nice podcast on trust protectors. If you want to listen for free, Parenting Impossible, the Special Needs Survival podcast. It's a great listen. It's about 40 minutes, and you can learn more about what a trust protector is all about and just dig right in. And that can be a nice combination of having a family member be involved and having some kind of an institutional or professional trustee. So that
Yeah, I mean,
might give
basically
you a little bit more insight.
I mean, trust protectors can do have a lot of different roles. In this particular context, what we're talking about is the trust protector, who could be that sibling maybe that really shouldn't be the trustee, can kind of function in the role of the board of trustees, so to speak, while the trustee is the CEO of the trust. And if the board of trustees thinks that the trustee, the CEO, just isn't doing a good job, they can remove them and replace them. That's one way to arrange something like this, so that the family member isn't, isn't in this role where maybe there could be some kind of conflict with the disabled beneficiary, their sibling. It relieves them of the responsibility of and the liability of being a trustee, but ultimately gives a family member the ultimate say in the management. So, what assets can we use?
So
Well,
people
real
always
estate.
ask about this. What can go in my trust? And then the other question is, how much should be in my trust? But what kind of assets can go in the trust? Well, certainly real estate, but there are definitely issues with putting real estate into a special needs trust. So,
I mean, one of them is that it creates potentially a lot of liability for the trustee. The trustee really has an obligation to go and inspect the property from time to time to make sure that it's not being wasted. Is the beneficiary inviting people into the real estate who might be doing things that they shouldn't be doing on the premises? And does that create liability for the trust and the trustee? There needs to be substantial cash to maintain this thing. You can't just leave a piece of real estate into the trust and that's it. How are the real estate property taxes going to be paid for? How's the roof going to get replaced when it needs it? Things like that. Lots and lots of issues. And then there's public benefits issues. How is the real estate, if this is the home of the disabled beneficiary, how is this treated by Section 8 housing? How is it treated by SSI, et cetera, et cetera?
right.
Cash and investments, of course, that's always welcome in any trust.
The easiest to manage for sure. And certainly they grow nicely. I know people always get nervous about the stock market, but tried and true, the stock market, even if it's cautiously invested, is going to grow over time, much more nicely than any other investments. And retirement plans are great
Now
too.
you can have you can have a retirement plan go into any trust, but there are issues which we're going to talk about near the end of the slide.
Right,
So I think
they're
I'll skip
coming up
over it
right now. And then life
And then
insurance
life
as well.
insurance, you can fund it with life insurance proceeds, but you don't want the special needs trust to own life insurance. That generally is not something that you would do. Okay, so recent developments, ABLE accounts in the Secure Act, and then we'll be at our Q&A section. Section.
Let's try to wrap up in the next 5 so that we can have time for questions.
Do what I can. Well, remember, we got started really with these slides about 10 minutes late, so I'm thinking we have another 15 to go, including the Q&A. I recognize that. So ABLE accounts were an attempt to basically, people say, oh, gee whiz, we have to go through all this trouble to set up D4A trust. We need to hire lawyers and manage it with a small amount of funds, and maybe we don't have the right people to be the trustee, all this kind of stuff. Or maybe we have a beneficiary who's perfectly capable of managing things, but they can't be their own trustee. Well, okay, so this is how able accounts came about. The idea was, why can't we have just a conventional bank account or investment account or something like that? Why do we have to have a trust? So able accounts were born. Like D4A trusts, they have a Medicaid payback. But there's a lot of other rules that got grafted onto it before they finally became law. So anything in the able account is not an available asset for public benefits purposes. There can only be one per eligible individual. First big constraint, the individual has to have become disabled prior to age 26, in addition to being disabled now. Contribution limits, no more than $15,000 per year from all sources combined. Plus, if the individual is working and is not participating in a retirement plan at work, et cetera, they can contribute up to $12,490 in the lower 48 states. Hawaii and Alaska have slightly higher limits. And all funds are non-countable for Medicaid purposes, but only the first $100,000 are non-countable for SSI purposes. The earnings are non-taxable. Distributions for qualified disability expenses are income tax-free, not income for public benefits purposes, and housing distributions for housing expenses, however, need to be used in the month of distribution for the housing in order to avoid being counted for countable income for SSI purposes. Unlike D4A trusts, where there's Medicaid payback from the beginning of time, here the payback is only for medical assistance provided by the state Medicaid program since the date the account was established. Who can establish the able account? The final regulations, which just were just published October 1st this year, create a hierarchy. The eligible individual or a person they select can establish it, but if the eligible individual is unable to, in descending order of priority, any of the following persons can establish the account. Annette, do you want to talk about the last one at all, or do we need to keep moving?
Well, I just thought some of this was a little crazy, and having a representative payee have access to money that they normally would not have access to was very strange, frankly. I'm a representative payee and also a trustee for people as well as a guardian. I fill a lot of roles as a fiduciary, and I just don't think it's okay. For example, many group home providers and agencies will be a representative payee, and I could not imagine having them have access to upwards of, $50, $80, $100,000 of family money, because they would have access as the representative payee. They would have access to the able account that got set up, just because they happen to, for convenience, because they're the residential provider, be set up as the representative payee. So now, right, that they would necessarily access that able account, but they could. So, I don't know. I don't know that. I don't know how comfortable I feel with that.
Well, I think we need to move on. It's potentially an issue. It was actually put there really for all well and good intention purposes. It was promoted by the, I forget the exact name of it, but there's an association of the 50 state treasurers that thought that this was a good idea. Okay, and then the final regulations, the last thing on ables, I think this is the last slide on ables. The final regulations added something really helpful and useful. You may or may not be aware, but a D4A trust, as soon as the disabled individual passes away, other than administrative costs of closing up the D4A trust, no other expenses, no other benefits, nothing can be paid until the state Medicaid agency is paid back. And this leads to what is known as the stinking dead body rule. Sorry, if the individual does not have a prepaid burial account. So the D4A trustee, who may be a trustee of a very small amount of money, is wrestling with, do I spend money on a funeral now when I still have a living beneficiary who really could use the money, or what do I do? So the final ABLE regulations just added this 2 months ago, that the ABLE account can pay for a funeral even if it wasn't contracted for prior to death, and that's allowable before the state Medicaid agency gets paid back. Last thing is the Secure Act. So from time immemorial, meaning the 1970s, when IRAs and 401ks and so on like that were invented, if you left your IRA, your 401k, to a beneficiary other than your spouse, because spouses have all kinds of great advantages for doing this. Notice how interested Annette's looking now. You could leave it to your child, and your child could take out, though the minimum distribution rule said, okay, your child can take out the funds as slowly as over their life expectancy. And this is really great because the deferral of income tax, because the tax only occurs when the withdrawals are made from the retirement plan, the deferral of the tax is not merely deferral of the pain of the tax. It's actually more real net present value after tax money for your beneficiary, and it can be an enormous amount more over time. So this was really a big deal.
It's huge. It's huge. I know that it's the end of the night, and to put the tax slides at the end of the night can be painful.
The interesting stuff.
It's really hard for some of us, Mark, who are not tax gurus like you are. But I have to tell you, this is huge. So I want you to pay attention, people, because this is a huge deal.
And let me tell you another reason why it's a big deal for special needs trusts. All right. So let's say a special needs trust is named as the beneficiary. All right. If all of the money has to come out fast, you don't have enough, the trustee doesn't have enough useful things to spend that money on for the beneficiary. So the trustee is going to keep a lot of the withdrawals of the IRA in trust and use them over the years as needed. Well, those withdrawals are taxed when they come out, not when the trustee needs to use them. And trusts have very compressed tax brackets. There's a slide on this, I think, next, but I'm going to talk about it now anyway. Individuals reach the top income tax bracket rates at like $500,000, $600,000. Top federal rate's 37%. Trusts hit the top rate of 37% on retained income at a mere $12,950 of income for that year. I said retained income because if the trust distributes it to or for the benefit of the beneficiary, it carries out that tax liability to the beneficiary. So small amounts of money coming out of the IRA not only produce less tax if retained to the trust, but also we have useful things we can spend it on for the beneficiary, carry out that tax liability to the beneficiary, who's almost certainly in a much lower tax bracket, maybe even a zero tax bracket. Great. Well, Congress says, well, we can't have this. So the Secure Act came along at the end of 2019 and said, okay, enough of that. We're tired of waiting for our money, money, right? Not yours. We're tired of waiting for our money. So no more of this, no more Mr. Nice Guy. like the Congress has ever been nice guy. No more Mr. Nice Guy. All the money has to come out of the trust or out of the retirement plan within 10 years of death. Thank you. Have a nice day. Well, they made a couple of exceptions, or well, actually a few exceptions. Surviving spouse, minors. But the ones that really matter here are the disabled and the chronically ill, which for our purposes, we're just going to say disabled. And that was it. And that's the way it stood when the House passed the version of the Secure Act that they passed in May of 2019. They passed the Secure Act by a vote of 417 to 3. I think it was bipartisan. It got hung up in the Senate because one person got mad about something, and it didn't have anything to do with anything interesting regarding the Secure Act. So Senator Ted Cruz, stopped it. but it was going to pass, but it gave us an opportunity to work on it. And we did. And we wrote to the, I'm telling you, see where it says this qualified special needs trust are also eligible to use the lifetime stretch out. You're welcome, because Special Needs Law Group did that. So we got that into the Secure Act as it passed at the end of 2019. So what that means is you can name the special needs trust as the third party special needs trust as the death beneficiary of the retirement plans and still get that life expectancy payout, but it has to be drafted with in certain ways, very particular ways, in order to be qualified. All right, so I've already told you about why this matters, and we're done.